Good afternoon. Apologies, we had a few technical difficulties just then. But welcome to Immigration Solutions Lawyers Seminar on Post-Deregulation, the consequences and challenges facing the migration sector and how to reunite the profession. My name, of course, is Anne O'Donoghue, and I'm hosting it and speaking for this particular webinar. Today's webinar will feature two speakers, myself, also Mei Liao, who is the team leader of the corporate section of the law practice, and of course we're delighted to have Marion Dickey, who is very well renowned within the migration industry, professionally working over many, many years, and recently completed her doctorate in migration law and looking at the migration industry. Now, I'm not going to speak about myself. I think I'm well known in the area. Marion's slide is on screen now. And I would like to start the webinar. Just a couple of words about Marion. She's a senior academic with in this area. She established in 2007 a pro bono migration advice clinic to service disadvantaged clients, and in 2002 was recognised for her commitment to human rights as a finalist for the ACT Australian of the Year. All the presentations by our speakers will be available. There'll be a chat box and a quanda at the end of this period. So if you have a question and you're not able to remain for the whole session, you can of course ask a question now, and your question can be answered at a later point of time with the quanda. So I will now put on my other role, and I will start the webinar today. Now, migration, next slide please, if we can have the next slide. Migration Law Monthly News. I thought it was important to touch on what is happening in the profession at the moment. With the Department of Health at the moment, we're currently vaccinating people in Phase 1A and Phase 1B. The states and territories will begin vaccinating people in Phase 2A in May, with all adults 50 years and over. Next slide, please. The second wave is now raging in India, and of course our sympathies go out to the people of India that are coping with a really difficult time at the moment. I think anyone who's been watching the TV at this particular time would have great sympathy for what's happening. India has recorded 360,960 new cases and another 3,293 deaths in the past 24 hours, a reported more than 17.6 million cases and 201,187 deaths. The reported numbers may be significantly underestimated due to the insufficient testing and the silent infection. Undercounting deaths not registered in government systems. Travel between Australia and India was suspended until the 15th of May due to the ongoing coronavirus crisis erupting in India. If I can have our next slide, please. Now, we've also in Australia, we have a visa processing paralysis at the moment. The numbers of temporary visa applications, both educational and vocational, are rapidly declining as Home Affairs still deals with a bridging visa backlog. I think we've got on record for the whole history of recording the most number of bridging people are in Australia on bridging visas. Australia now has the biggest number of bridging visa holders in the history. It nearly doubled since December of 2019. This reflects the much longer processing time in deciding a visa application made onshore. More than 70,000 temporary visa holders left Australia from December 2019 to February 2021. The numbers of students rise sharply in March of 2020, but gradually declined since then. Much less visitors arrived due to the border closures and less working holiday makers given the weakness of the labour market. Next slide, please. The travel bubble, which has been recently announced, with Australian citizens and permanent residents can now travel to New Zealand. The travel restrictions between Australia and New Zealand have been lifted. Australian citizens and permanent residents can arrive and leave New Zealand without undergoing the mandatory 2 weeks quarantine. Travellers must be present in Australia or New Zealand for 14 days immediately before the flight or voyage of the outgoing aircraft or vessel departing. The Prime Minister has stated that they're also looking at Singapore, Japan and South Korea. Next slide, please. Now, travel exemptions. Temporary visa holders in Australia can depart at any time. However, they will generally not be permitted to return, and they need an individual exemption to enter Australia. And this includes providing critical or specialist medical services, including air ambulance, medical evacuations, and delivering critical medical supplies. A foreign national with critical skills or working in a critical sector in Australia. A foreign national sponsored by an employer to work in Australia in an occupation on the priority migration skilled occupation list. A student completing 11 and 12 or year 11 and 12 with government endorsement, a student in the final 2 years of study of a medical, dental, nursing or allied health professional university degree must have evidence of a confirmed placement in an Australian hospital or medical practice which begins within the next 2 months. Travelling for compassionate and compelling reasons. Of course, the firm has done a lot in this area under the compassionate and compelling circumstances, and these decisions are made by the ABF, the Australian Border Force. Foreign nationals must hold a visa and an exemption before travel to Australia. So you need to apply for an exemption at least 2 weeks, but not more than 2 months before your planned travel. Next slide, please. The National Cabinet has decided that travel to high-risk COVID-19 countries presents a serious health risk to the Australian community. Travel exemptions for travel from Australia to the Republic of India will be limited to very urgent circumstances. I suppose really the reason why Australia has done so well in COVID, apart from the vaccine rollout, is because we have treated our borders very, very seriously. Limited circumstances include critical workers providing assistance to the country of destination, COVID's response, persons undertaking travel to Australia, a national interest, or persons seeking urgent medical treatment for a critical illness that is unable to be treated in Australia. Australians and permanent residents' exemptions to leave Australia include if the travel is part of a response to the COVID-19 outbreak, if the travel is for business employer, travel to receive urgent medical treatment that is not available in Australia, travelling outside Australia for compelling reasons for 3 months or longer, and travelling on compassionate or humanitarian grounds, if the travel is in the national interest. Next slide, please. Next slide, please. Thank you. The government has recently released a new stream for the post-pandemic economic recovery, which is effective from the 27th of February 2021 to the 30th of June 2022. Specified classes of persons is employed full-time as an essential staff member of an overseas business that is relocating to Australia and will assist Australia's response to the event and will assist with the establishment of the business operation in Australia. COVID concessions for parent visas, location for grant. The below parent visas are now available to be granted onshore. Normally the applicant is required to be outside Australia. The parent subclass 103, the contributing parent 143, the contributing parent temporary visa class. The below parent visas can now be granted offshore, and these are the age parents, subclass 804, and the contributing parent 864. The above concessions only apply to visas lodged prior to the 24th of March 2021. No end date has been prescribed at the moment. Next slide, please. Now, the Minister's Special Envoy, the global talent, I suppose, is the real ace card that the government is promoting at the moment to bring in the best and the brightest to Australia. The Minister has created a Minister's Special Envoy, and applications are accepted onshore and offshore. Priority sectors for global talent visa eligibility have been expanded, and the Prime Minister's Special Envoy can directly nominate suitable, exceptionally talented candidates on behalf of the task force to apply for global talent if they are likely to make a significant contribution to the Australian economy. I watched a very interesting webinar on this. I think it was put out by the MIA, and I think Werner was interviewed and saying, well, really, if you are nominated by the Special Envoy, the bar is quite high, so it's not easy to meet that standard. The pie chart that we have on the screen deals with the percentages of global talent approvals, which deal with the areas of medtech, energy and resources, ag tech, space and advanced manufacturing, fintech and cybersecurity. Next slide, please. Now, the composition of the migration professionals in this migration profession, which is really combined now since post-deregulation. Statistics as at the 30th of June, new statistics will be released soon. This was 2018, we're a little dated, but you've got a composition of registered migration agents, you've got registered migration agents with 10 years experience, non-lawyers agents with a graduate certificate in migration law and practice, then you've got holding an Australian practicing certificate. There's 2,538. I think there might be some more since then, especially with the deregulation. And of course, you've got the agents that have completed the Migration Agents Authorities approved courses. So that gives you an idea of what we are dealing with now. But there will be, I think, a lot more influx of younger lawyers working under the supervision of principal lawyers moving into this migration profession. Next slide, please. The visa assistance from registered migration agents. Registered migration agents, RMAs, provide assistance in lodging more than 10% of approximately 3.4 million visa applications. It's quite a lot of visa applications. It is noted that assistance was sourced more on visa subclasses that had greater technical requirements. The visa classes which required the most assistance in lodging an application were employer-sponsored, the previous 457, which is now known as the 482, and the temporary skilled shortage, business, skills and family. The pie chart then shows that 10% displayed digitally. Next slide, please. The new arrangements for the Australian legal practitioners, which we talked about in our last seminar, and the dual regulation, of course, this came into being on the 22nd of March. A definition of what immigration assistance is. Now lawyers can give immigration assistance without being registered. Next slide, please. I've noticed, from a practice point of view, I've noticed a fairly smooth transition. I think the public have accepted that lawyers can now give advice without being registered as a migration agent, and junior lawyers can work under supervision of a principal. Now, the next slide, I think, deals with application refusals. If you have a look at the 2019 to 2020, I mean, we had quite a few numbers, I think 352. The peak seemed to be the 2016-2017 period. Next slide, please. It is a matter of consumer choice who you choose post-deregulation. I think that slide is self-explanatory. I mean, there are many, many different types and varieties of people working in this profession at the moment. You've got it from the accredited specialist immigration lawyer who holds an unrestricted practicing certificate. You've got a lawyer who holds an unrestricted practicing certificate. You've got a lawyer who holds a restricted practicing certificate. You've got a restricted ALPC holder working under the supervision of an unrestricted ALPC holder. You've got registered migration agents, and then within the MIA itself you have a structure of fellows, associate fellows, registered migration agents. So there is a range of choice to choose from. Next slide, please. The effect of post-deregulation. Who can help with your application? I think we got that screenshot from the Department of Home Affairs. Deregulation may have caused confusion to consumers as they are unsure of the necessary qualifications relevant to migration assistance and advice. Certain parts of immigration law is more complex than others, such as employer-sponsored visas. Figure out who is the best person to assist you and how complex your matter is. That is a good question to ask. You have to look at the complexity of the matter and take a range of opinions and then make an informed choice. Next slide, please. Again, this slide deals with the different choices within the system, which I've spoken of before. I won't spend much more time on that. If we can go to the next slide. Now, why should I use an accredited specialist immigration lawyer? Well, I think the law societies in different states and territories have been spending quite a bit of time promoting the idea of accredited specialisation. It's a peer recognition of the level of your specialisation. There is a certain amount of experience that's required. To become a specialist solicitor, you must demonstrate 5 years' experience as a full-time practitioner and 3 years specialising in immigration law. And the Law Society for New South Wales, to use an example, I believe the LIV also has that specialisation, and also the Law Society of Queensland. The New South Wales Law Society is meticulous assessments in communication, problem solving, client relations, as well as specialist area of law. An accredited specialist must renew their accreditation to practice law and membership of the Law Society annually and every 3 years in Victoria, plus ensure they maintain their high level of skills, knowledge, by completing additional professional development points. Now, I've given the link to both the Law Society New South Wales and the Victorian Law Society in this slide. Next slide, please. That talks about there are 44 accredited specialist immigration lawyers in Victoria and 51 in New South Wales. Next slide, please. United but not divided. Migration agents are professionally qualified, and there are many excellent agents out there. As lawyers specialising in immigration law, we have always been open to collaborative work in order to provide professional support and guidance. Case takeovers and referrals. Migration law has areas of greater complexity that may not be in the expertise of certain professionals. There are certain times when you feel you need to refer matters out, and we're saying today, if you're not comfortable in a certain area or feel that you may not have the experience required, there's no harm in referring something out. It speaks more about you as an individual that you recognise that and you're prepared to refer it out. Next slide, please. New peers, young lawyers. It is expected that the deregulation will now mean that more young lawyers will enter the immigration law practice. We're here to help with complex cases which require experienced practitioners, including the business investment programs, the reviews, AAT, and ministerial intervention casework. Next slide, please. Our review stream, talking about the practice, most people think that the only option after a visa refusal is out of Australia. However, what most people don't know or realise are their rights and available options for them to rectify the situation, including the AAT, appeal, MIU, intervention requests, and also federal court options. The practice handles all these types of review situations. It's a matter really of working out the strategy that's going to suit this particular client, analysing the situation and making that call. It may not be appropriate for a client to undergo cross-examination at an AAT hearing. This may be something that may be more beneficial to take to the minister Or if you've got a decision and there is an error of law and the prospects of success for federal court are good, then that may be an option that you would also take into account. The only issue with federal court is if you are unsuccessful, you have a debt to the Commonwealth, and that debt to the Commonwealth needs to be paid before you look at any other visa option. If it is possible to lodge another visa, a lot of people are affected by Section 48 bars, unless, of course, the Minister intervenes and waives that bar. Talking about the practice, our review stream provides high-quality forensic review of clients' immigration history, submits detailed and comprehensive submissions to the Ministerial Intervention Unit, as we do to the AAT. I think it's very important that quality submissions are put forward in this. Now, this is where some migration agents may need assistance and may not feel comfortable that their expertise falls within that ability to put together a comprehensive review. Next slide. Okay, sorry, we just had a little technical hitch there. We sort of blacked out. We haven't left you, but we had a technical hitch. This is the wonders of technology that we're dealing with on a daily basis. So the next person I would like to introduce is May Liao, and May is the team leader of our corporate stream, and she's a registered migration agent and the team leader at Immigration Solutions Lawyers. She's co-authored articles in Corporate Immigration Review and Modern Slavery, published on Who's Who Legal and ICLG. She holds a Master's in Accounting, completed at the Australian National University, and is currently studying law at the Legal Profession Admission Board course at the University of Sydney towards admission as a solicitor in New South Wales. Over to you, May.
Okay, I will go through some complex matters that we recently handled and got a successful outcome. And these cases include humanitarian visas and business cases. So first one, that we helped a 99-year-old grandmother to remain in Australia and got a successful outcome from the ministerial intervention and helped her to remain in Australia permanently to stay with her family. So the applicant arrives in Australia on a visitor visa and subsequently applies for the aged parent visa, which is subclass 804. The applicant was 87 years old at the time of application, but in January 2012, the department sends a request for the applicant to undertake a health assessment and complete police checks, which the applicant completed in February 2012. The applicant suffers a back fall later in 2012 and breaks her hip, resulting in hospitalization and rehabilitation. The department does not send the applicant any further correspondence until December 2018, when they request that the applicant complete another health assessment. The medical officer of the Commonwealth refused the parent visa on the basis that the applicant does not meet the health requirements. So the tribunal affirms the department's decision but makes a recommendation for it to be referred to the Minister for Intervention. So we provided a submission outlining the following points: the hardship that the applicant's Australian citizen family members would face in not being able to care for the applicant, who was in her late 90s at that time, in the last few years of her life, the applicant's advanced age and health problems, so the lack of care and support for the applicant if she had to went back to India. So the unintended consequences of legislation, that is the fact that the applicant has had to meet the health requirements in 2012 but could no longer meet it afterwards in 2018. So the Ministerial Intervention Unit and Department of Home Affairs suggested that a medical treatment visa to be lodged for the applicant. However, we did not take this option because it would not give the applicant permanent residency as it was intended to. So the minister ultimately intervened and granted the applicant a former resident visa, which would ensure she's able to remain in Australia for a longer time. So the next case we will need to go through is a child case. Child saved from death sentence. The applicant was a 10-year-old girl from Bangladesh who was born with a rare and life-threatening condition since birth. So this was a condition where a person's abdomen organs are outside the body. So the applicant was advised to come to Australia to do a medical treatment visa in order to have life-saving surgery that was not available in the home country. So in 2004, the applicant was brought to Sydney and the operation turned out to be successful. Although the operation was successful, the applicant continued to have ongoing and serious complications after the treatment, which required constant care from her doctors in Australia. So the applicant had undergone 6 major surgeries in 7 years and was warned that she may still need to undergo another surgery. While the applicant was still being treated, the Department of Home Affairs informed the child's parents that they could no longer stay in Australia and had to return to Bangladesh. We took on the matter on pro bono basis in December 2010 and had to show something new, as it was going to be the third ministerial intervention request the applicant would be making. It was a hard case. We could not get an Australian doctor to say that condition was life-threatening for political reasons, and so we sought the opinions from the doctors around the world on the applicant's current condition, and we successfully argued that sending the applicant back would be the same as issuing a death sentence on the child. And finally, in 2012, the minister at that time, Chris Bono, intervened to grant the applicant and her parents permanent visas. So apart from assisting these compassionate humanitarian cases, we also do some significant business cases which would significantly benefit the Australian economy. So we have a highly renowned construction company in the local area in Sydney sought immigration solutions lawyers' assistance to apply for travel exemption for their highly skilled employees to bring them overseas and complete an essential project in Sydney. They were eligible to apply under the category of critical skills per our assessment. So the employees were essential in the completion of a major construction project which required their experience and knowledge to install highly specialized technology, which was not found in Australia before. So the construction project value was over 100 million Australian dollars. So our firm carefully prepared the travel exemption, presenting a strong case for the overseas workers to arrive for the large-scale infrastructure project. So in this case, actually we managed to get through and get a very quick, successful outcome while there was a second wave of pandemic outbreak in Europe.
I remember that case well. It was difficult and it was very well handled.
Yes.
And you were instrumental in that, and congratulations to you for that.
Thank you, Anne. We managed to fast-track the applications and lodged in 3 days and got the approval within 7 business days. So in relation to travel exemption, actually apart from the inbound requests, we also do the outbound requests. Our Australian citizen clients needed to travel to Lebanon in order to oversee their crucial business activities there. They had already a refusal in the travel exemption application prior to seeking assistance from our firm. So amidst the COVID-19 pandemic outbreak, it was crucial that they review and implement their corporate strategy post-COVID-19 to continue the viability of their business in Lebanon. So our firm assisted the clients in providing a detailed application to request for travel exemption. The submission detailed the client's travel was a significant Australian investment activity, and we include financial documents and a letter of support from the Senate, in addition to a range of other supporting and critical documents to the submission. So it turned out to be successful again, and the clients were granted an exemption to travel overseas.
I think there's one more case study,
Yes.
and then we're must get on to Marion. Marion's been waiting very patiently.
Yes. So the last case we would like to discuss is a recent approval just happened days ago. So it was a multinational power supply company that they require a civil engineer from Asia to enter Australia. So that engineer was actually from a state-owned power supply company, and we applied for a short stay work, highly specialized stream subclass 400 and an inbound travel exemption. So the visa and travel exemption was granted within 10 business days.
Thank you, May, for that. And
Thanks, everyone.
now we're going to cross over to Marion Dickey. I did give Marion an introduction before, but words fail me. She's done so much and she's made such a contribution to the migration profession, and I'm absolutely delighted to have Marion here today. So I'm sure you're going to enjoy her presentation tremendously. Marion, it's over to you now.
Oh, thank you, Anne. I'm hoping everybody can hear me. We've had a lot of difficulty before, so I'm sorry about that. If we can go to the next slide, hopefully it shows something. No? Yeah.
I think we're just waiting for the technical transfer.
Yep. I'll just keep going a little bit. This is a little bit of a change of direction because I've just completed my doctorate, as Anne said. It was called the protégé effect, but it was about migration agents and the migration profession. My thesis arose from a broader research project at ANU, and it had 3 other researchers. It included other practitioners such as Lisa, she was Lisa O'Hara at that stage, Lisa Channisman. So really dedicated and experienced migration agents were involved. We took some graduates, and they were newly registered migration agents who were in sole practice with at least one client file. And the aim of the project was to see if we could replicate supervised practice within a virtual space. My analysis found that this was a successful project, and with the success arising from the design of the online community practice that we created and which we designed to be a supportive workplace, particularly for practitioners. So I wanted to talk about some of that today. The doctorate was heavily influenced by 3 academics, and one that's of interest to all immigration lawyers in the US is Leslie Levin, and her work is very accessible for anybody without an academic background to read. She did 2 studies of immigration lawyers in the US and how they actually learnt to practice in a field that was separate from other practitioners. She found things like working in a non-adversarial situation, coming from a migrant background. These sort of issues were common amongst the US immigration lawyers, and there's something that's common amongst RMAs and migration practitioners in Australia. Etienne Wenger is a bit more academic. He designed the concept of communities of practice and social learning theory, that is learning from each other. And Michael Arrow did successive and long-term study on how to practice, particularly for lawyers, in a supportive workplace. So next slide, please. I defined a professional virtual community of practice as an intentionally designed, informally mediated community where a group of individuals separated by geography and time can join together in conversation within a virtual locality to collaboratively create knowledge, reflect and learn individually and communally through sharing their practice experience about a specific domain of practice. A specific domain means, of course, an area of practice such as law or medicine, or in our case, migration law. But it was intentionally designed for professionals, not just a group of people networking. The words used are intentional, of course, because there's a difference between a group of workers or a network of professionals and a community of practice. The difference is the intention of why you form a group or the goal of what you're trying to achieve. The deliberate intent to steward a domain of knowledge and sustain learning about it and advance that knowledge is what makes you a community of practice. Next slide. So the doctorate considered an analysis of the field I was researching, and that is the field of migration agent advice. And I found that it could be considered an emerging profession because, of course, only being regulated since 1992 and not having many of the factors of a profession such as law, the migration agent advice profession should be called emerging and not quite settled. And it's not settled because I found there was 3 key aspects that held back the development of the migration advice profession in its development. And one was dual regulation, and the other is the competing professional representation. And Anne and I had a very long discussion on this yesterday. So that is, if we look closely, we have the Migration Institute of Australia, we have Migration Alliance, and we had the Law Council. So we had different bodies all purporting to represent their members and at the same time represent people who are providing advice on migration law. And it was disparate. So there wasn't this cohesion given by one professional body. And we have different educational entry points. So people who had a law degree and a practicing certificate could become registered migration agents. Others had undergone different educational entry points, such as way back, they just did the MAPKI, which is a multiple choice exam. When I did my study in 2002, we were sent a booklet, and 10 weeks later, I did a 3-hour exam. We moved on to the graduate certificate in migration law and practice, and then now we've moved to the graduate diploma plus the capstone. So there's all these different entry points, and it gives people different ideas of their expertise and different arguments about their expertise. And that reduces the cohesion of the profession. So since March, we've worked in an environment that does not include the first aspect that was holding people back. And in some extent, it doesn't include the second, because the end of dual regulation removed the need for lawyers to be registered, and also removed the Law Council from their influence over RMA, over people who are practicing as registered migration agents. And that leaves the profession of what we now call RMAs with the challenge of how they can move forward and address the 2 issues affecting their growth. But also for lawyers practicing in this space, the key questions that arise are how you work with or alongside migration agents. And Anne's done a wonderful job of continuously stressing the benefits of RMAs and how people can work together and continue to be collegiate in their work. Now, my research project involved 30 migration agents, and they were RMAs and lawyers with practicing certificates and without practicing certificates, who all had registered as agents in 2012 and 2013. And they stayed in their community of practice for 1 year, and they were facilitated or mentored by 2 migration agents during that time. And the study found there was no difference between those who had a law degree, who practiced as lawyers, or those who were migration agents and who'd come in from other degrees. Indeed, many of the RMAs also had worked in professional areas with clients, so they knew they had practice experience in the sense of working in a practice with clients, either as psychologists or other sort of professions. And many held qualifications higher than a law degree. In that study of 30 RMAs, there were 6 doctorates, and they were doctorates in science, physics, very, very qualified people. Others had worked in education, worked in law, one had been AAT members, had worked in the department. So it was a broad range of agents. And it was the learning to practice in migration law, in this specific area of law, that was the issue for people who were in the community of practice. And working in an area that is client-focused and non-adversarial, and learning how to navigate this unpredictable area of law with constant changes in policy, constant changes in law and processes, and that was the key factor in how they grew as professionals. Together, they were able to share their experiences and often what is called tacit knowledge or tricks of the trade in how to navigate their new practice. So I would suggest that lawyers beginning to work in this area or moving into areas of migration law that they are unfamiliar with continue to build relationships across this professional boundary. There's a huge well of knowledge and expertise out there, and good relationships must be reciprocal. So if you're seeking advice from migration agents, don't hesitate to ask for their advice, but at the same time, be open to them asking you for your advice or your guidance. Because migration law has boundaries that cross into many areas of law that many lawyers, including migration agents, have no knowledge of. And this is family law, criminal law, property law, many areas of law that many migration clients will ultimately need advice upon. And you can either assist a migration agent with that advice, you can refer other people, but this working across a professional boundary will only enhance your work. So the lessons learned from my research are that there is a benefit in working together across this professional spectrum, and there is also a benefit for RMAs in the end to dual regulation, as well as the benefit that lawyers are feeling. So thank you, Anne, for inviting me to share those findings.
We're right? Oh, excellent. Well, I found that fascinating, and it was such an interesting topic for you to do that. And I do think it's so important that we cross-fertilise, whatever you like to say, we reach out. The American lawyers and working in this area are extremely collegiate with other practitioners. And I think collegiality is so important because everyone has something to bring to the table. And people have strengths and weaknesses in certain areas, and work to your strengths, and where you need to bring in someone else from a different area, by all means do so. I think the migration industry is very similar to a topic that to my heart, which is the modern slavery topic, which takes into account so many different areas of law and activity. And migration is very similar to that. It crosses across so many boundaries that I think working together in a collegiate way will provide a much better outcome for clients. And that's where I'd like to see the profession, the migration profession merging. I don't like the them and us. I think that gets the client nowhere. There are some cases that a migration agent should handle, and there are some cases perhaps a lawyer should handle. There are cases where they should come together and work in a cooperative manner for the benefit of the client. So I think this is opening a whole new debate, and I hope this conversation can continue. And thank you again, Marion. Now I might check the chat box to see whether we've got questions. I think we had over 60 registrants when I last checked for this particular webinar. Apologies for the technical difficulties we've had today.
We do receive some interesting questions.
So would you like to start?
Yeah, the first one would be addressing to you. And just now you talked about the bridge and visa holders have been the biggest number in the history. So what do you think of this, and why is this will be a problem?
Well, I think it's a bit of a double-edged sword. I think you can blame COVID to a certain extent of this, but I still think the numbers far outweigh just blaming it all on COVID. I think there are some issues that go to the integrity of the visas. I think there should be more integrity checking, and whether in fact people are making applications just to stay here and extend their time, as opposed to whether the applications are meritorious. There are many competing unprecedented factors which have snowballed. I acknowledge all that. COVID, border closures. The government has been very accommodating in allowing certain visas that were normally granted offshore to be granted onshore. However, I think it is a concern that we have a record number of people on bridging visas, and I think perhaps the integrity of the certain visa classes should be looked at, because some people may be holding bridging visas and taking positions that other people that are disadvantaging other people. But they're my preliminary thoughts. Marion, do you have a viewpoint on that?
From my other work with the Senator, we get a lot of people who have been caught up in bridging visas, and unfortunately a lot of them sort of ended up on a bridging visa E due to things like getting stuck, really getting stuck, which is what you're talking about. So for instance, students who couldn't return back to their country of origin because there was a travel ban from like Colombia or South America, places like that, then found that they overstayed one day, and then were advised to overstay one day, and then were granted a bridging visa E with work or study rights, but now can't move anywhere. They're sort of stuck on there. So it depends on the bridging visa that people are on, and the length of time they're given it, and that sort of varies. There's no consistency. So there's I echo your concerns. It's a concerning thing to have happened. Yeah.
The bridging E visa is almost like being on death row. Perhaps that's not a good analogy.
No.
But it's like the worst type of bridging visa you can be on, and it does restrict you in many ways. It can be a lifesaver in some situations, but of course it doesn't have work rights, and it does restrict you in many other ways. But like, for example, if the matter's before the minister, you've got to be on a bridging E visa. But yes, next question.
Yeah, we have another couple of questions. The typical one is that we have two audience. They say that they got a visa refusal, and they want to know that whether it is worth going to the administrative review tribunal to have a merits review, and whether that will be a good option for them. And one of them is under the employer sponsorship, which is a very complex matter.
Well, really, you have to make the merits assessment on the particular case.
Yes.
Are we talking about a refusal of a sponsorship or a nomination?
That was a nomination stage, and the visa was refused subsequently.
As a result of that, it depends really in whether, in fact, the merits are there for the nomination. If it's not, and there's merits in the application, then you might have to rethink the strategy there, because of pursuing a review for the circumstances of elongating someone's time in Australia is not the way to go.
Could be at least 2 years waiting time.
What is your viewpoint on that, Marion?
No, I agree with you totally. It's not a great way to extend their time
if there's
here.
no merit in the nomination review, then but there's merit in the visa applicant themselves, and they've got more to offer. I mean, it may even be a situation of getting a decision on the papers if the visa is associated with it, and then taking it to the ministry if there is merit on that, because of course the client would be Section 48 barred in this particular situation. So every case needs to be looked at and assessed with its own merits.
We can't make assessment just based on clients' online description. So you're most welcome to come to Immigration Solutions lawyers and book a consultation with us.
Now the next question appears to be very loaded. In what circumstances would you recommend using an RMA over a lawyer and vice versa? I thought, seeing you did the doctorate, perhaps you should answer that first, Marion.
Thanks, Anne. It is a loaded question.
It is a bit of a poison chalice, I think.
Well, I think it doesn't even come down to using an RMA over a lawyer. It comes down to the area of expertise each of those people have. So a lawyer without any expertise in a specific visa subclass area, or even in migration law, like practicing new, would not have the benefits of an RMA who had been practicing successfully for 10 years or 5 years. So it really just depends on reputation, on the complexity, And if your case is overlapping into other areas of law where you think a law firm or a lawyer can deal with both or with all aspects of it, I don't think it's definitive, really.
No, I agree. It's a very loaded question. It really is. It depends on the circumstances. It depends on the matter, and the expertise of the individual involved who's going to be representing them. I mean, I really think you need to know your matter, and when a client is out there in the marketplace looking for the best representation, I think they have to really know what the key issues about their matter is, and then look for someone who has experience in that particular aspect of the matter. I know that's a lot for the individual to have to cope with, but you really do need to know the matter, and perhaps a little bit more collegiality and working with a network of referrals and building something forward is the way to go, so that the client ends up in the right hands, or
Yes.
it may be in the right hands of working collegiately with a migration agent and a lawyer in certain aspects of it. So I think one needs to be pragmatic and think a little bit laterally, and really we're all working out there for the benefit of the client. These are not lines of demarcation that are drawn in the sand. I mean, what we're working for is the benefit of the holistic client and to get the best result for that client. There's one more question, is why is providing pro bono migration advice important? Marianne.
It's incredibly important. There's a lot of people who really cannot afford legal advice or migration advice, but also it helps you as a practitioner, because sometimes these are the most complex and difficult cases, and you learn a lot about that area of law and how it works, and you're really giving back to the community. So it's incredibly important. I encourage everyone to actually take on some pro bono work at some time in their career.
Yes, I would have to agree with that most wholeheartedly. I've found actually some of the most fascinating cases I've ever done have been pro bono, and it does extend your expertise, and there's a very good sense of well-being. And if you've got a young team of lawyers, I mean, there's nothing better for a young team of lawyers or a young team of migration agents working on something that's for the common good, and you feel that you're actually able to contribute and do something helpful. And I do know the IBA has a very strong pro bono committee, and a lot of the big firms also do pro bono work. But I think you certainly extend your practice. And, again, it's also the moral imperative. There is a moral imperative to assist people if you feel that they're in a situation where they just cannot manage, and if your practice or your migration agency is in a position to do some pro bono work, then I think one needs to do it. Marion, you raised an interesting issue. You mentioned the protege effect in relation to young lawyers and RMAs entering into the migration field. Why do you think this is important, and how can they find mentorship?
I think they need to. One thing that came out in the study was why they were reluctant to find mentorship, and that might be a better way to look at it, because then people can think that through if they're in a position to mentor someone or are looking for a mentor. And the reluctance came because they felt the reciprocity, they were unable to give back to that person. So if they kept asking, for example, if I kept asking you a question, and then I asked you another question in a fortnight, and then I had another one in another week, they began embarrassed that they were taking all your time. And what they didn't have that embarrassment or that experience within the community practice, because they were all committed to helping each other. But in reality, if you mentor someone, or even if you were just casually help them, you don't have to be a mentor that's there all the time. That reciprocity might not come straight directly back to you, but the person who's learnt might then be able to help somebody else. So it's acknowledging how that knowledge goes on, and how you then spread your knowledge or your assistance to other people. So it doesn't have to be a one-on-one equal thing. I mean, most people who are experienced don't expect that, but in the future, in a couple of years, you might call upon somebody who was, who you've helped through a bad patch, or who you've helped learn something. You might then all of a sudden go, well, wow, now they're an expert in refugee law. I know nothing about that. And you might give them a phone call. So it works both ways. I would encourage people not to be scared of asking each other for help, and not to think they have nothing to offer, because very often they do, or they may offer it to somebody else who's new as well. So it's a giving culture you need to develop, and a collegiate community of practice means that you help each other without expecting payment of equal assistance. That's really what it
I
is.
know the Law Society of New South Wales has a mentoring role, and I am a mentor for the Law School of Notre Dame. Um, does the MIA have any mentoring um, program at the moment? Are you aware of the MIA having a mentoring
They
program?
do have one. Well, they did a year ago, and I haven't been a member for a little while. So they did have one, and it was quite active, with a lot of senior practitioners taking people either into their office for times, or regularly meeting with them, with new practitioners. So yes, they did.
Well, I think that's something that should continue. And if whoever our audience is today, the 60 people that have registered, we may have even more listening. Uh, don't feel embarrassed to pick up the phone if you want some direction. I think most people would be prepared to give you that direction. I know I've never knocked back someone who's wanted some direction in the past, and I think the mentoring is an excellent way to start. And we are, after all, a community, and we should be acting like a community,
Mm.
and working collaboratively across many, many different areas, because it is a wide diversity and area of practice. Um, one question which is a final question. What role do you think women can play in the migration profession? Talking about diversity and both regional and gender diversity, what type of role do you think women can play?
I think they play an important role. Women are more inclined to talk to each other and ask for help. So reaching out to each other is probably something women do easier. Traditionally, they've been like 47% of the population of migration agents, so it's weighted in favour of men. But I think they have a particular role, maybe not so much a nurturing one, but one of a leadership that shows that they're not frightened to actually assist and help each other, and move across the boundaries of professional space. I think they're probably not as protective of their boundaries as some men can be, but that could be just a very gendered statement, Anne. I really don't know. I know that we actively encouraged women students at ANU to try and get that balance up, because it had been quite
Well, I know
low.
the IBA is also very keen on gender diversity, and I
Yeah.
always have tried to include women. And with the IBA Immigration Nationality Committee, I was very happy to be able to put Marielle Lewis forward as the young lawyer liaison member. And I think this is the first time that we've had a young lawyer liaison member of the Immigration and Nationality Law Committee, and it was very nice to be able to put a woman there, and
Yes.
also an Australian,
Yeah.
because I think I was the first Australian that was
Wow.
the co-chair of the Immigration Nationality Law Committee for the IBA in the history of the IBA. So it's very nice. Not that we want to make men feel outside. My son works in the practice and in the social media and webinar sphere. He didn't do the introduction today, but men play a vital role as well. So I think we've now come to the end. I know we've got a lot of other questions, but we're happy to answer those offline. And I want to thank you, Marion, for your time today. It was wonderful having you speaking, and I hope to do this again. I want to thank May, and I want to thank the production staff, who I think were tearing their hair out at certain times today, but we got there in the end. And thank you all. And I think a recording will be available. It will be an edited recording because we did have a couple of technical hitches throughout. But thank you again. And
thank you.
Thanks a lot.
Thank you, everyone.
Thanks, Maria.
Thanks, Marion.